Dear professors, dear colleagues, dear PhD students, and ladies and gentlemen, thank you very much that I'm here today with you, and I would like to give you gratitude on behalf of the Professor Derencinovic, who unfortunately could not be here today with us. I have a presentation which is far from too long, but I will give a presentation in milestones, and I will try to show you how the political context and the events in Croatia affected the reform in criminal law. Mostly substantive, but also a procedural criminal law. So, bearing in mind this, I would like to say that you all know how the Croatia looks like, or I hope you do, and some people say that it looks like a girl who runs towards I don't know what. Let's say we are now in European Union, so we got what we wanted. We have, you will see the importance of these figures after the, let's say, the end of the presentation. Now this is only introduction into the subject. We have, by the last census, which was in 2021, less than 4 million people. So before that, in 2011, we had more than 4 million people. So we have a drop. Lots of people emigrated. Today, we can say we call ourselves as parliamentary democracy. Of course, as you all know, as most of our neighbors, we were part of Yugoslavia, socialist regime, communist regime, and we had the laws as well as such. But we also have an Austro-Hungarian heritage. So our criminal law and criminal path goes from 1952 with Austrian Criminal Code and follows 7 sorts of criminal or criminal procedural code. These informations are not on the slide. We have a code from 1929, 1947, 1951, which was kind of a big step forward because the the country which we actually took as our guidance was Switzerland. Then we had a code, a criminal code and criminal procedural code from 1977. After that, we got independent in 1991. But when we had our independence, we didn't have any laws. And we took over those laws from Yugoslavia. But the reform started, and the first criminal law, as well as the first criminal procedural law, as I can say, the Poland friends and professor had the same path. We got it in 1997, both new laws of our independent states. What I have to say that we abolished that penalty, but we abolished it in 1990, before we got independent, because our constitutional court said it's unconstitutional to have a death penalty. Bearing that in mind, I want to say, I know that criminal law is very often when we are talking about the legislator and the legislative, it's very boring, but I would like to make it more interesting. Why am I saying this? This is ripple separation of powers, which you all have. This executive branch of power, you see this, I don't know if this works, no, the laser. This guy totally on the left, it's our current president, Zoran Milanovic. People call it Zoki. The other one, the person on the right, is our prime minister, Andrej Plenković. The people call it Plenki. So, the Zoki and Plenki, this is the rare opportunity to see them together because they very often don't go together and they have their own reasons for that. So we have a president and a prime minister. The second branch is parliament or legislator, and the third branch is judiciary. Why I'm saying this? Because we have triple separation of powers, and then again, it's all interconnected. The president actually suggests or proposes who? The president of the Supreme Court. Of course, the president of the Supreme Court is elected by parliament or appointed by parliament, but this is the prerogative of the president, and nobody else can be chosen than this person who president proposes. Then there is other interconnection between this executive power and judiciary. Our prime minister or the government proposes who? The chief prosecutor, the general state attorney. Of course, parliament elects it, appoints it on a 4-year period, but you see the connection. Why I'm saying this? I'm saying this because I don't know if you're acquainted to our I wouldn't say embarrassment, but it's not something that we brag about it. Our ex-prime minister was convicted for criminal offenses, for corruption criminal offenses, lots of it. This prime minister was before you saw that Zoran Milanovic, now is the president of the state, but in 2011 he was the prime minister. Today he is the president of the state. Before him, a former prime minister, he committed some criminal offenses, corruption criminal offenses, in period of 2004 to 2009. So this period actually, if you bear in mind that government appoints, actually proposes the chief prosecutor, these criminal offenses were not prosecuted. They were prosecuted after a new government came. Okay? So this is why I told you that, the whole introduction part. I wanted to show you the systematization of our courts hierarchy. We have Supreme Court, of course, and we have court of regular and special jurisdiction. The court of regular jurisdiction are municipal and county courts, and the courts of special jurisdiction are, we have, actually we don't have misdemeanor court because today is part of the county and municipal courts, but it's not totally like that because we have one special misdemeanor court, it's Zagreb misdemeanor court, so it's not very easy to comprehend all that, but just bearing in mind that we have such divisions. Then we have the high misdemeanor court, we have high commercial court, we have commercial court, high commercial court, administrative courts, and high administrative courts. But the things are more complex. Why? Because in criminal law and in criminal jurisdiction, we have municipal courts, we have county courts, we have high criminal court, and then we have a Supreme Court. So we have 4 courts, but not 4 instances. Because this high criminal court, it's a very young court. It started with its work on 1st January 2021, and its case law is still expected, but it's functioned very well. Today it has 11 members, but by the law it should have 15 members. Still, we are waiting for 4 members to be elected. So, Constitutional Court is not a part of our judiciary system. It's beyond this triple separation of powers, but it has a real big impact on the criminal law cases, of course, and it tries to work in accordance with European Court of Human Rights case law. Judges and then we will skip to this criminal justice system, and I wanted to say that this criminal justice system has its territorial jurisdiction, and it has also the real jurisdiction, which is defined by severity and complexity of the criminal offenses. And now to skip to something what is more interesting. We have 3 prosecution services. We have State Attorney's Office, we have Office for the Suppression of Corruption and Organized Crime. It's a special body, some sort independent part of State Attorney's Office with its own director. And we have the European Public Prosecutor's Office, which is actually new, and it started with its work on June 1st, 2021. So I will skip all this. I won't be very, but I will go to this substantive criminal law. So after 1997, when we got our new criminal law in independent state, it had so many amendments, not 84 as I heard in one country, but 14. And our legislator thought it was too much, so they enacted new criminal code, penal code, actually in 2011. So I have to say that as Hungary, we are celebrating our 10th, or we are actually somewhere in between 11 and 10. I will say why, because we got the law in 2011, but we had vacatio legis. You know what vacatio legis is? For 2 years. So the penal code started with its application in 2013. It was very interesting. Why? Because we had one amendment in between. So I think it's something totally new that you can amend a law before it when it entered into force. It's very interesting, but that was First Amendment. Till this day, this is our current penal code. It had 8 amendments. And as Professor Šepac said, we had a lot of interventions. We had a big reform. We reformed special and general parts. We have a substantive criminal law is divided to the general part and to the special part. But I had to say, I was laughing, not to your presentation, but to the situation. We amended our substantive criminal law, especially in sexual offenses, because one NGO group said that the rape wasn't defined as well as it should be. So the Prime Minister said, okay, then put those NGOs into the task force, and they actually changed our law, criminal law, and changed the definition of rape. What we had this big reform, but due to the time frame, I won't be going into details, but Professor Derenčinović and I wrote one article and a report about this, our current legal system, criminal justice system, but legal system as well. So if you're interested, please read the article for more informations. But I wanted to say that hearing all of your presentation, we had very similar issues, very similar problems. We defined new sanctions. We had partial suspended sentence or conditional sentence. That is something totally new. Then we have we have statute of limitation. The statute of limitation was prolonged. For children, it doesn't run off till they are 18 or till they are adult persons. So yes, we have lots of similar things as all of you, as my colleagues. In special part, we totally reorganized a special part, and we have now a totally new chapters, totally new criminal offenses. We have crimes, economic crimes offenses, sexual abuse of children offenses, and we have crimes against humanity, human dignity, which are the most severe, those violent offenses, the crimes, genocide, etc. Regarding the Croatian criminal procedural law, the reform started a little bit earlier, in 2008. I would like to just to remind you that case of our Prime Minister went 2004 to 2009. He was committing offenses. Why I'm saying this? Because not only the professionals, the NGO affect the criminal code, but also, of course, the criminals and sometimes the politics, or more often the politics, and some cases from the politics. So in Croatian criminal procedural law, we had before this new law in 2008, in 1997, it was totally inquisitorial features of criminal procedure law. In 2008, it was a mixture of adversarial and inquisitorial features. The procedure was, we had an example of, believe it or not, Italian criminal code at that time, but it had been amended for 14 times, so it doesn't look at all as the first version of this code. We have now today criminal prosecution, which is actually governed by the State Attorney's Office. So we have this State Attorney prosecution and investigation. We have also the special, we introduced the special of investigative judge. This is a special institution. It was something very similar before that, but it has a different jurisdiction or power. So I wouldn't go further. As I said, the more detailed information are in the text. I would just like to show you the regulation and the acts which we have, because all those previous presenters and presentations actually kind of are connected to our subject, but I don't have a time to go through that, because we had also a Juvenile Act in 1997, and now we have a new Juvenile Act also in 2011, so with more amendments. But we have something what is called the legal, the criminal responsibility of legal persons, so Croatia has it, and we have it from 2003. These are all the regulations from Constitution, Constitutional Law, the Courts Act, the Law National Judicial Council, the State Attorney's Act. Why I put it here, not in the criminal part, because State Attorney's Office has two divisions, civil and criminal division. Then we have State Attorney Council, and now the regulation for the criminal law. It's, as you see, a lot. We have a lot of laws, and we have to know them. This is maybe, I don't know if you're going to share the presentation for somebody who is doing comparative work. Here are the, I'm sorry, but I have to say, most of those laws, the acts, are not in English, are not translated. But if you need something, just contact me, and I think that Professor Szilágyi has my email and connection, and thank you very much. Thank you very much for listening, for being, and thank you very much, Professor Szilágyi, for having me here today.